everyone. Thank you for joining us today. We're excited to get started. So I want to first introduce Matthew Raphan. He is a partner at Raphan Law Partners, LLP, one of the New York's premier elder law firms. His practice areas include estate planning, wills, trusts, guardianships, and Alzheimer's planning. Matthew's personal and professional experiences with family members with Alzheimer's give him a well-rounded perspective when it comes to legal needs. He's a member of the New York City Bar Association's Legal Problems of the Aging Committee, the New York Bar Association's Elder Law Section, the Nassau County Bar Association's Estates and Trusts, Elder Law, and Surrogates Courts Committees. Matthew also speaks pro bono in New York City throughout the year, explaining legal issues facing the elderly, and is a registered speaker with the CLC's Legal and Financial Speakers Bureau. So without further ado, thank you, Matthew, for being here with us today.
My pleasure. Thank you, Kara, for having me. I'm sorry that you guys can't see me. It seems we're having some technical issues, but if any of you want to have a Zoom with me after the presentation, we can certainly schedule something, and I'm happy to accommodate as best I can. So hopefully this will be just as helpful hearing my voice as opposed to seeing me speak face to face. So this presentation is about guardianship and conservatorship. This is sort of a hot topic these days in the news, as many of you probably have noticed. You know, Britney Spears being the most obvious example of that. And it's funny that it's mid-October and we're approaching Halloween, because this is sort of a scary topic, as you'll come to find over the course of this presentation. I'll try my best to, not scare you too much, but, guardianship, as, you'll see, is something that we should all seek to avoid as best we can. It's something that none of us ever want to go through or be the subject of. And if any of you have any experience with guardianship or conservatorship, then you can certainly chime in, and I'm sure that your experience is the same. So before I get started, a couple of notes about the program. Number one, as Kara mentioned, we're a firm in New York. We practice in New York State. We're located in New York City. So, the focus of the presentation will primarily be geared towards New York law, but that's not to say that this won't be helpful to those of you across the country. And I know we have attendees, across the 50 states today. The good news is that the vast majority of what I'll talk about is sort of common among the 50 states, even though some of the terminology and the mechanisms might vary state by state. For instance, in New York, we have a power of attorney and a healthcare proxy, which I'll talk about shortly. In other states, the healthcare proxy is known as a power of attorney for healthcare. Conceptually, they're exactly the same, but the terminology does differ. So, keep that in mind. And, to the extent we can make this interactive and, conversational, I really think that increases and improves, the presentation. So I know we have a lot of attendees here today, so I don't know if it's practical for people to chime in. So maybe what we can do is, if you use the chat function to ask some questions, and I'll try to stop, intermittently throughout, and maybe Kara could read off some questions and we can, go from there. And I'm happy to interact with you guys. So
yeah, definitely.
Perfect. Thank you, Kara. So in order to understand guardianship, first we have to understand how we plan for our own incapacity. And there are two primary ways of doing that. One is through the use of a power of attorney, and number two, through the use of a healthcare proxy. And I'd like to go into these documents a little bit at the start because, in my view, they really are the most critical documents that really everybody should have. Anyone who's over the age of 18, it's really imperative for you to have both of those documents. And I'm sure that all of you already have them. I have no doubt about it. So this will be, a repeat and a reminder for all of you. But, to the extent that you don't, certainly you might want to take some notes. This is really a critical piece of information. So the power of attorney allows us to choose people to handle our financial affairs for us if we one day lose the capacity to handle our own affairs, right? So if we become unable to pay our bills, manage our investments, go to the bank, write checks, etc., the power of attorney is able to step in and do that for us, which is really unbelievably convenient and a powerful tool to have. The power of attorney generally terminates automatically upon our death, which means it's only good to the extent we're alive, right? After we are deceased, the power of attorney ceases to be effective. And at that point, the representative of our estate will commence handling our affairs. The powers that are outlined in the power of attorney can really be tailored to meet our individual needs. They can be as broad or as limited as we like, within reason. I have clients who come to me from time to time and they say, Matthew, I understand that the power of attorney is really critical to have, but I don't necessarily want to give every single power under the sun to the person I'm going to appoint. Can I limit it in some fashion so that their powers are a little bit more restricted? And the answer, at least in New York State, is absolutely yes. We have the ability to really tailor our powers to accommodate our individual circumstances. A note about the document itself. In New York State, our legislature actually drafts the document. So everyone in the state of New York who's doing a power of attorney has the exact same form. That's not the case in other states. For instance, in New Jersey, there is no statutory form. So, a lawyer or an individual can create their own document, and it doesn't necessarily need to be identical to their neighbor's document. But in New York, we are bound by the statutory form. So everyone in this state has the exact same document. So, for those of you in New York, if you're looking to do this on your own, you want to be sure that you're using the correct form. It was most recently updated in June of this year. If you use the prior version, it's not going to be effective. So that's very important to be mindful of. Most of you probably know this answer. The answer to this question, but I get this question often. People sometimes want to appoint more than one person to act on their behalf at one time. Let's say, for instance, somebody has 2 or 3 children, and they want all of those kids to be able to act as their power of attorney simultaneously. That is certainly something that they can do. You can have multiple people, multiple agents acting at one time. In New York, you can choose whether they have to act together or whether they can act separately. So there's some flexibility in that regard. But the answer generally is yes. You can have multiple people acting at once. The last, I could talk about power of attorney for a long time, incidentally, but the last thing I'll mention is something that comes up pretty often too. There's, again, people often understand the critical nature of having the power of attorney, but some people don't feel super comfortable having the document be effective right away. So luckily we have a mechanism that allows the document to only be effective upon the happening of an event. What do I mean by that? Typically, what happens is if someone doesn't want the document to be effective now, they can stipulate that the power of attorney is only effective when they lose capacity. And how is it determined when someone loses capacity? Usually it's when their doctor examines them and signs a document indicating that they've lost the ability to handle their own affairs. And only then is the document effective if the person doing the power of attorney so chooses. So that document is called a springing power of attorney, which means it springs into effect upon the happening of an event. And typically that event is when we lose capacity to handle our own affairs. So let's talk briefly about the healthcare proxy. And again, in some states, this is known as the power of attorney for healthcare. It's really quite similar in concept to the power of attorney, except that it deals with medical-based decisions, not financial. So there are a couple of key differences. Number one, at least in the state of New York, the law only allows us to have one healthcare proxy acting at one time. We cannot have multiple healthcare proxies acting simultaneously. What we can do is have multiple agents acting in succession. So I can have my neighbor Jane as my primary healthcare proxy, and I can have my friend Joe as my successor. That's perfectly valid in New York State. And again, you know, if any of you are looking to do this in a state other than New York, you know, I would suggest speaking to local counsel there to make sure that you're doing it properly, because again, the laws do vary state by state. But conceptually, the healthcare proxy and power of attorney are really quite similar. Another key difference is that the healthcare proxy in New York only becomes effective when the person loses capacity to handle their medical affairs. So only when the person cannot speak on their own behalf with respect to their medical care or surgeries, medications, what have you, only then will doctors look to the healthcare proxy to make those sorts of decisions for them. And just incidentally, I want to mention something called a living will, which is kind of an addendum to the healthcare proxy. Most people these days, we find, feel that if they are in a state of unconsciousness and doctors feel that there's really no reasonable chance of them returning to any quality of life, most people these days feel that they would not want to be kept alive via life support. You know, certainly I respect all opinions on this matter, and you know, in my view, all stances on this subject are completely valid, and it's a very personal choice. But we do find increasingly that people are very averse to being kept alive via life support. So if you happen to feel that way, I do suggest creating a living will, and again, it might be called something different in your home state, but it's really important to have that. And, you know, just a quick caveat or anecdote, I should say, about the living will. You want to be sure, especially if your wishes are not to be kept alive via life support, you want to be sure that the person you're naming as your healthcare proxy is willing and able to make that happen for you. You know, we've seen pretty often in our practice over the years where a client feels particularly strongly about not being kept alive via life support, but the agent that they appoint as their healthcare proxy, for whatever reason, might have a personal, you know, aversion to removing someone from life support. And again, I certainly respect all sides of the coin on this issue, but my point is, you want to make sure that the person you're appointing, A, knows what your wishes are, and B, is going to be willing and able to make that happen for you. You know, we don't want to necessarily appoint someone who has a differing viewpoint on the issue. We want to make sure that, you know, the person we're appointing is in line with us with respect to life support and staying alive artificially or not. I hope that was clear. That was just sort of an introduction, and you'll see how it ties in to the guardianship world in a few minutes. Kara, I wonder if we might want to stop for now and see if there's any questions that have percolated, and maybe I can answer some before we move on.
Definitely, and we definitely have a lot of questions that are coming in. And just to remind you guys, Matthew and this firm, they work with this stuff every day. So these are questions to be bringing up to them, and you guys have their information right in front of you. So the first question that we do have, Matthew, it says, you know, at what point in the downward spiral of dementia will an attorney, deem that the person's not capable of signing a POA or a healthcare proxy or I would say other documents as well?
Yeah, that is an excellent, excellent question. The answer to that really does vary significantly state by state. Each state has their own laws about a person's capacity to sign documents. And the level of capacity does vary based on the document that we're talking about. I can tell you in New York, the law is that in order for someone to have capacity to sign a will, and, for those of you, I'm sure all of you know what a will is, but what a will it boils down to is a document where we choose who receives our property upon our death, who is in charge of administering and distributing that property, and, it wraps up our affairs, our lifetime affairs after we are gone, essentially. But back to the question, so in New York, in order to have the ability to sign a will, one has to be aware of what their assets are in a general sense and who their next of kin are, or the natural objects of their bounty in legalese. So, that doesn't necessarily mean that we have to know down to the penny exactly what we own, and we certainly don't have to know our account numbers by heart, but we sort of have to be able to verbalize, in a general sense, what we own by way of assets. So, but that rule is not necessarily the same for a healthcare proxy or a power of attorney. Generally, the person just sort of has to understand the nature of the document and what they're signing. And obviously, that's a very broad set of criteria. So, for those of you who, again, are facing this issue in a different state, I definitely suggest speaking to a local lawyer in your home state who can hopefully illuminate what the criteria are for signing documents in your locality.
Mm-hmm. Definitely. And I think one of the organizations that does that is also the national one as well. So anything like that comes up. We do have another question. We're actually getting a lot of these questions coming in, so I'm going to try and get to as many as I can, Matthew. But another one is asking if the healthcare surrogate, can they override a POA on where the loved one can be treated/live?
That's a very important question. In terms of where the person lives, that's really the purview of the power of attorney. That's considered a financial power, right? So in terms of if the individual is living at home or living in an assisted living facility or a skilled nursing facility, aka a nursing home, that's generally the purview of the power of attorney. The healthcare proxy is more dealing with the person's medical providers directly. In other words, who's going to speak to the doctor about a surgery that needs to happen? Who's going to decide which sort of medications the person's on in conjunction with the doctor? That's more of the purview of the healthcare proxy. I hope that answers the question.
Yeah, I think so. And then I just want to say, if you guys have any in-depth personal questions that are being asked, that is something you can connect with them just in terms of context. I do have someone who asked, this might be a short, simple question, where can you locate forms, whether it's in New York or other states, about proxies and POAs? So if you're not going straight to another law attorney, is there another resource to get connected to those?
Yes, absolutely. So, Google is really a great resource for this sort of thing. A few quick Google searches really can illuminate for you, in your particular state, what documents you need and where they're available. Your local bar association is also a good resource. You can reach out to them and ask for general advice. In New York, where we have a statutory form power of attorney, and I think, I imagine many other states have that as well, that's widely available on the internet, through the New York State Bar Association's website. And I imagine it's similar in other states as well. And the healthcare proxy, at least in New York, it's sort of a more informal document, and they don't have to necessarily be the same one from another. So, what I would suggest is do some quick Google searches, and B, definitely reach out to your local bar association for assistance. On that point too, I get the question often, do you need a lawyer to do these documents? And the answer, at least in New York, is generally no. You don't necessarily need a lawyer to do them. People do them on their own from time to time. Look, my joke about this is you don't really need a dentist to do a root canal either, but I do suggest using a dentist for that. And why? Because a lot can go wrong. And if the document is not signed properly or executed properly, in New York there have to be witnesses and a notary. And if one I is not dotted or T is not crossed, then it could be a problem. And for something as critical and important as our incapacity planning, I always generally recommend that you have some help with that. It's just too important to mess up accidentally.
And let me know if I have more questions. I can give you another one, or if you want to continue.
We could take one more.
Okay, great. So this person is asking specifically if the person can't physically sign, so they actually can't use their hand and sign, does a verbal statement, can that be sufficient for an attorney to draw up a POA?
Well, that question is really, the answer is going to vary state by state. But generally speaking, especially in New York, the person doesn't have to physically be able to sign the document. You can imagine, a quadriplegic, for instance, who has no function of their arms or legs, but cognitively is completely intact. Of course, they should be able to execute a power of attorney or a healthcare proxy or a will. How it works is you can verbally direct someone to sign on your behalf in New York, and that will work the same way as if the person physically signed on their own.
Great.
Okay, good. So let's move on to the topic of the day, which is guardianship. And you'll see how our prior discussion relates to guardianship in a few minutes. So, again, with the terminology varying state by state, in some states, this is called a conservatorship. In New York, we call it a guardianship of the person or property. So a guardian can be appointed for someone's personal needs, similar to a healthcare proxy, or they can be appointed to handle the person's financial needs, similar to a power of attorney. So if you hear the word conservator or conservatorship, those are generally interchangeable. But, so how does this work, and what is it for, and why is it so scary? I'll explain. Let me start by saying this. So generally, and again, I'm going to talk about New York specifically, but I imagine that the rules are very similar state by state. Generally, somebody who has an interest in the well-being of someone else can petition the local court. In New York, it's the Supreme Court, to have a guardian appointed for that person. So who can start this proceeding? Really, it could be anyone with an interest. It can be a neighbor, it can be a friend, it can be a family member, it can be a doctor, it can be a hospital, it can be a nursing home, it can be a lawyer, it can be an accountant, it can be anyone who has an interest in this person's well-being, right? So once the process begins, and the way to begin it is to file a set of papers called a petition with the local court. Here in New York, within 30 days, generally, a hearing will be set, 30 days from the filing of the papers. And it's similar to what you might see on TV. Think Law and Order. There's a judge in a black robe. There's testimony from witnesses. There are lawyers generally on both sides asking questions and examining witnesses. And the star of the show, so to speak, is the person who's alleged to be incapacitated. Here in New York, we call that the AIP, the alleged incapacitated person. But not only that, whenever this process begins, the court appoints various court personnel or appointees to participate. What do I mean by that? In New York, there's someone called a court evaluator who basically serves as the eyes and the ears of the judge. And this person conducts an investigation into the circumstances surrounding the guardianship. So we'll use me as an example. Let's say that Kara, who is a friend of mine, is really concerned for my well-being. And she says, I really think that Matthew needs some court intervention and he needs some help. So Kara is going to petition the court to have a guardian appointed for me. As soon as she does that, the court will appoint a court evaluator, which again is the investigator, and also probably a lawyer to represent my interests in the proceeding. And I'll explain why I would need a lawyer for this. But the court evaluator does a very thorough investigation. She will look into my finances. She'll visit my banks. She will go to my house or apartment and look through my personal effects. She will interview my family members, even if I haven't spoken to them in 50 years, or I've been estranged from them for my entire life. They are still interested parties to this proceeding, and they will be interviewed and communicated with and have an opinion about my welfare and what happens to me ultimately. As offensive as that might seem to many of you, and it is, that's just the law, especially here in New York. Why would I need a lawyer for this? Why do I need a lawyer representing my interests? Well, if a guardian is appointed for me, it's basically a loss of my civil rights. As blunt as that might seem, I no longer have the ability to handle my own affairs. I no longer have access to my financial accounts, my bank accounts, my assets. I can no longer make decisions about where I live, about what I spend my money on, about if I travel. Basically the court is being asked to remove a person's civil rights, to take them away, and appoint a third party to oversee those rights. So, this is sort of the scary part, right? Think of Britney Spears. She, certainly went through, from just what I read in the papers, she had a history of some, probably, mental illness or mental difficulties. And, she had a guardian appointed for her, which was her father, and I think someone else. But she really was unable to, she claimed, get on birth control or get off of birth control or travel or work or manage her money the way she wanted to. And she was beholden to a guardian or guardians who were appointed by a judge who she had never met. So, it can be extremely invasive, intrusive, and expensive. How is it expensive? Well, all of those court appointees that I mentioned, the court evaluator and the lawyer for the alleged incapacitated person and the lawyer for the person who brings the proceeding itself, how are they getting paid? You should be seeing red dollar signs flash in front of your eyes when I say that. Because all of those fees are paid by the person who's alleged to be incapacitated, at least here in New York. They are responsible for all of those fees. So it could be upwards of $15,000, $20,000, $25,000 at the end of the day or more, right? So it's not only is it invasive and intrusive, but it's expensive. Now, I don't mean necessarily to speak negatively about the guardianship process as a whole. I mean, certainly it's necessary and it's worthwhile for those people who have neglected to plan for their own incapacity. And again, how do we do that? We do a power of attorney and a healthcare proxy. So if someone becomes incapacitated and their bills are going unpaid and their rent is going unpaid and they're being evicted by their landlord and their insurance policies are not being paid and they're about to lapse, and they haven't appointed anyone to handle those things for them by virtue of a power of attorney, there's a void. And that's not good, right? So the guardianship process is there to fill that void. But it's something that we should all seek to avoid to the extent we can. And luckily, here in the United States, we're able to avoid that quite easily by doing those simple documents, the power of attorney and the healthcare proxy, for frankly, usually a very nominal cost. So the idea that we can do those things and save ourselves enormous financial expense and enormous heartache and headache, it's really a no-brainer. So the last thing I'll mention, and then we can open it up to questions, is, some guardians are good and some guardians are not good, right? Here at Raphan Law Partners, we are court examiners. So not only do I personally serve as guardian for many people, but, we have lawyers here who are examiners. So we examine the work and the behaviors of guardians and make sure that everything is on the up and up. And needless to say, over the years, we've come across examples of misappropriation and theft and neglect and, all sorts of things. Because, again, some guardians are good and some guardians are not good. Often, the court will appoint a guardian who's, off of a list, a third party accountant or lawyer off a list, rather than a family member. So it's someone who you've never known and have no relationship to, all of a sudden handling your day-to-day affairs and deciding where you live and how your money is invested and how it's spent. And that, again, should be disconcerting to all of us. So right on time for Halloween, I hope I've sufficiently scared everybody.
Or just making us, we're going to have to call and ask more questions to get more answers.
Exactly.
We're definitely getting a lot of questions coming in. And again, this is helpful because you guys are getting the opportunity to ask questions and get feedback on it. So I'm seeing one person, this person's asking, is local court synonymous with surrogates court?
Well, so the terminology does vary state by state. In New York, there is the surrogates court, which deals with people's estates when they pass away, and also some guardianship matters. But I know, for instance, in other states, it's not called the surrogates court. Sometimes it's called the probate court or the circuit court or the Supreme Court. So it really does vary state by state.
Okay. That's good to know. Someone has just asked, can a guardianship be petitioned anonymously?
Oh, that's a really good question. In New York, I think the answer is yes. I've never had occasion where the petitioner was anonymous. I have seen many instances where the person who's alleged to be incapacitated was kept anonymous. We've had, and you can imagine in New York City, we've had many celebrities who have been the subject of guardianship proceedings. And, often, there's an inclination or, we want to keep those things private because we don't, the idea that it would be partial to public view is, probably not that good if we're dealing with someone who's famous.
Yeah.
Generally guardianship proceedings are public. So, for me, in my example where Kara's petitioning on my behalf, it would be a public proceeding. So anyone could come down to court and sit in and look at it. Now that I think about it, I did have a case a few years ago where the petitioner was kept anonymous because she was a famous individual. And we didn't want anyone to be able to go down to the record room of the court and search her name and be able to, locate those records. So, as long as the court sees that there is a legitimate reason to keep a name anonymous, generally a request like that will be granted.
Mm-hmm. Yeah, and now we have another question, and this individual is asking for guardianship and who gets appointed. Does a family member have any say in who's appointed as a guardian? As you mentioned, Matthew, you served as a guardian for some people. Is there ways that a family member can ask other people other than family to serve as a guardian?
Yeah, absolutely. So, in New York, and I imagine in the majority of states, there is a preference for family to serve, right? If the court sees that a family member is willing and able to serve as guardian, and there's not a conflict of interest, and there's been a good relationship among the family for historically, then yes, the court will generally appoint family over a third party. But A, it's not a guarantee, and B, when people realize that how difficult it is to be a guardian and how many reporting requirements there are, oftentimes people aren't very eager to serve. Here in New York, guardians have to file annual accounts and annual reports with the court every year. So every penny that comes in and goes out has to be accounted for. And, they have to file a report, detailing what they've done to, see the person over the course of the year. In New York, there's a requirement that the guardian visit the person at least 4 times per year. And again, that might vary in other states, but anyone can be the guardian. There is a preference for family, but it's certainly not a guarantee.
Yeah, and that's just good to think about. Like you said, if you're making these paperworks and who you want in charge and you don't want it to be in family, that's something where you could bring that up with an elder law attorney and let them know that.
Yes, absolutely.
Yeah, so I do have another question, and this individual has asked, what's the difference between the POA for the healthcare specifically versus the living will, and would guardianship, how do I say this? Would the guardianship eliminate those paperwork?
I think I understand the question. So the first part of the question is, what's the difference between the healthcare proxy and the living will? So the healthcare proxy is where we are appointing someone to make medical decisions for us, right? The living will deals with life support, like we talked about a few minutes ago. So that's really a description of your wishes when it comes to are you kept alive artificially by life support, or are you allowed to pass away naturally and painlessly? And how do those documents relate to the guardianship? So, and thank you for this question, because I forgot to, I should say this more clearly, just so everyone understands. Here in New York, if a guardianship proceeding is started and the court sees that the alleged incapacitated person has planned appropriately, in other words, if they see that the person has a power of attorney and a healthcare proxy, then the judge will toss the case out of court, assuming that those documents were done validly and the people who are appointed are acting appropriately. So the court is not going to appoint a guardian if the person's already done a healthcare proxy and a power of attorney. It would be redundant, right? They've planned for their incapacity, so there would be no need for a guardian. So that's why it's so important and critical to do those documents. A, because we don't want there to be a void if we lose capacity, and B, we don't want there to be a guardianship if it ever comes down to that. Again, we want to avoid the guardianship proceeding to the extent we can.
Yeah. And then I have another question. When should someone petition for emergency guardianship? Is that something people can do, and how long would that even be effective if it is allowed?
Yeah, so I like that question. It does come up from time to time. The court will usually appoint what's called a temporary guardian if there is an emergency circumstance. So what would be an example of that? I'll think of a few examples we've dealt with over the years. The most common usually is, let's say that the person who's alleged to be incapacitated has a lawsuit that they could file on their behalf. Let's say that there was some neglect in a hospital, for instance, and there's a lawsuit that they could file, but they haven't done it because they're incapacitated, right? They don't have the wherewithal to hire a lawyer and file a lawsuit. There's something called a statute of limitations, which means there's a time frame, a time limit that people have to file a claim. And if the statute of limitations expires, then that claim is lost. That lawsuit can never be filed, and it's lost. So we've had cases over the years where there's a lawsuit that's ripe on someone's behalf, but they're incapacitated, they can't file it, and the deadline is next week, and we get the case, and we have to act immediately. And it's not sufficient for us to file an ordinary petition because, the hearing won't be for at least 30 days. And by that point, the statute of limitations would have run. And that would be really terrible for the person who needs the help and who the lawsuit is on behalf of. So we have filed an emergency application, and with relief that a temporary guardian be appointed immediately so that the lawsuit can be filed and preserved. And, therefore it's not, the benefits of that lawsuit would not be lost for the incapacitated person. And there are myriad examples of that. But generally, if there is an emergency circumstance, if someone is about to be evicted from their home, or if someone has a life insurance policy that hasn't been paid and it's about to lapse, anything that needs to happen immediately, generally, as long as you bring it to the attention of the court, they will, be pretty, willing to help and give you some temporary relief.
Yeah. I do have a special situation with this person. So it's if it's a man, right? And I would say we'll put this in context of how much we're able to provide for this information. But if the person has the POA, some dementia, but there's not a definitive diagnosis, but they're going through a divorce attorney, and the other divorce attorney is pushing for guardianship. So this seems like kind of like a complex question. So what is something that could help this individual navigate the family dynamic to best balance the aging care concerns, right, that's coming up in this issue, but also divorce proceedings? Do you ever have intersectionality with different types of situations, Matthew?
Oh, that's a really complicated question. Yeah, I don't know what state that person's in who asked that question, but I definitely suggest that they seek counsel, with respect to that issue, to get very specific and guided advice, because that's a very delicate scenario. I will tell you, generally, and look, this happens often. A divorce proceeding is started by the spouse who's well against the spouse who's unwell, and with the hope that the unwell spouse will not really be able to, fight or represent their interests properly. And the well spouse hopes to sort of, get away with something, right? So that's a very common scenario. Generally, if the court sees or suspects that one of the spouses is unable to represent themselves appropriately and does not have a lawyer, they can appoint someone called a guardian ad litem, or a GAL.
A GAL?
GAL, yeah. And the GAL's job is to represent that person's interests, but only in that divorce proceeding, not anywhere else. So it's only confined to that specific proceeding. And that way, the court is satisfied that all of the parties involved are represented properly, and that no one is being taken advantage of. And that's a really great mechanism to make sure that the proceedings are fair. So, to that person's question, if divorce proceedings have already been started, you might want to ask the court to appoint a guardian ad litem. And again, the terminology might be different in a different state, but, at least in New York, it's called a GAL, a guardian ad litem. That might be a good first step.
Yeah, and I think that's a great question to ask, because as a lawyer, do you have a lot of, crossover with different types of lawyers in regards to things when you are going through the paperwork with other people in those proceedings?
Yeah, absolutely. Here at our firm, we only handle elder law. So we only do estate planning, estate administration, guardianships, and Medicaid work. But, we often deal with matrimonial lawyers, in the context of, divorce proceedings and, all sorts of, personal injury lawyers. So, it does mesh. But, I definitely, here's my advice. For those of you who are looking for a lawyer, you just want to make sure that the person who you're going to has experience in what you're looking to seek help with. Check out their website. Word of mouth is always nice. Ask them for referrals. Just like any professional that you go to, whether it's an accountant or a doctor, you sort of want to make sure that you're getting the proper advice.
Yeah. And we do have another question that came in. So thank you for following up on that. Again, just to be specific, you're going to need to check in with your state in regards to that, because obviously there's different state laws. We do have this question coming in. Is there any advice that you can give, Matthew, for guardianship and conservatorship when it regards individuals who are living with developmental disabilities and dementia?
Well, yeah, that's a very broad thing, developmental disabilities.
It is broad, yes.
Yeah.
Touched on it a little bit here and there.
Yeah, sure. Again, if the person has dementia or any sort of disability and they're unable to handle their own affairs and they haven't done a power of attorney or a healthcare proxy, and there's a void in that something needs to happen that cannot. In other words, a bill needs to be paid, but it can't be. Investments need to be managed, but they're going unmanaged. Life insurance policies need to be paid. The premiums need to be paid, but they're going unpaid. If there's any sort of lapse or risk to the individual, then a guardianship or a conservatorship might be appropriate. Again, although we seek to avoid it, sometimes there is no avoiding it, and it's there for a reason. It's there to protect people, right? So ultimately, it is a good thing. It's just something that we should all, again, want to seek to avoid if we can. And the way we avoid it is by doing a POA and a healthcare proxy.
Yeah, and it's just ultimately preventive in the end when you're able to meet with, a lawyer like Matthew himself and to go through the process and set things up ahead of time prior to, if someone had a diagnosis later on.
Exactly. That's right. The law, to Kara's point, the law thankfully allows us to, pick and choose the people who we would want to help us if we lose capacity. And that's a really wonderful and powerful tool. So we should all take advantage of it. We should all choose who we want to handle our financial affairs. We should choose who we want to handle our medical affairs. Otherwise, we're beholden to what a judge decides who we've never met and who doesn't know us personally. So, who would opt for that when we can choose ourselves? That's what it comes down to.
Yeah. I do have someone who asked, if I don't have any children myself and my spouse passed away, does the guardian, and I think we touched on this, does the guardian have to be family, or who else can I appoint if I don't feel comfortable, like I don't have a trustworthy relationship with other people?
Yeah, so I get this really often. Some people don't have close family members to appoint. It can really be anybody. It can be, hopefully you have some close friends who would be willing, maybe a neighbor. It can be a professional. It can be an accountant. It can be a lawyer. So there are always options, and I'm happy to strategize, with people who feel that they have no options jumping out at them for who to appoint, but I find that there really is always somebody. And you just want to be sure that the person who you're appointing is aware that they're being appointed, right? You want to have the conversation with them in advance. We don't want to surprise anyone. Happy birthday, surprise! You're now my power of attorney and healthcare proxy. Hope you enjoy, because it's a big job and it's a big responsibility. So we want to make sure that the people who we're appointing are aware and that they're willing and able, and that they're going to be doers, right? What do I mean by doers? They're not going to be people who, sit on their hands and let the bills go unpaid and let the policies lapse. We want to make sure it's people who, can run around for us, can go to our banks and, hire help for us if we are diagnosed with Alzheimer's one day. And, it's a big responsibility. It's a big ask. But oftentimes people are more than willing and able to help. So if anyone wants to strategize with me about who they can appoint, I'm happy to strategize with any of you.
Yeah, so it's something like as simple as like if I didn't have someone, I could like call you, Matthew, and be like, hi, I don't have someone. Could you be like can we set up guardianship and appoint, you as that person, right?
Well, yeah, it wouldn't be a guardianship that we set up. It would probably be a power of attorney and a healthcare proxy to start, right?
True, yes.
That would be ideal. But, sometimes it's too late, to Kara's point. If it's too late, then we might have to, strategize about doing a guardianship if the person can't sign documents anymore, so. But yes, definitely the healthcare proxy and power of attorney are what we should strive to do first.
Yeah. I do have someone else who has a question who is brought up. So if the person, what would the process be like once a person's been appointed POA, but we have concerns they might not be acting in the person's best interest? I'm assuming this might come up for you guys a lot, potentially, Matthew.
Oh yeah, absolutely. That's that's something that we don't like to see. If someone has a concern that a power of attorney is not acting in the interests of the person who appointed them, then the court always has jurisdiction over those things. So, you can always file papers in the court. Usually it would be to commence a guardianship, quite frankly, and let the court be aware of what's happening. The court evaluator can look into the circumstances and make sure that everything is being handled properly. And if the court finds that the power of attorney is not acting properly, they can always revoke the power of attorney and appoint a guardian instead. So that's a scenario where a guardianship probably would be warranted, at least to get some sort of investigation going.
To start the process.
Yeah.
Well, let me see. We do have time for like maybe one more question, Matthew, if able. If a person is a spouse automatically POA, or do they still need to provide documentation to appoint them even though they're married?
I love the question. This is a great last question. Spouses, at least in New York, are not automatically power of attorney and healthcare proxy. So even if you're married, you still have to do these documents and appoint your spouse, and also have a backup person in case your spouse is unavailable. But just because, we have a married couple does not automatically give them the right to handle their spouse's affairs. So they have to specifically be appointed by a power of attorney and a healthcare proxy. That's a great question.
Yeah. Well, thank you for being with us today, Matthew. And again, my apologies for the technical issues. But of course, we are going to be sending out information with the Raphan Law Partners and Matthew's information. So you guys will have access to that afterwards. So that way, if you have any more questions that come up, you can certainly reach out to them. So I appreciate you being here with us today.
My pleasure. Thank you, Kara, for having me. I'm sorry you couldn't see me talk, but you heard me. Next time, we'll make sure that the video is working. Thank you guys for the great questions, and feel free to contact me if you want to talk more, okay?
All right. So with that, we'll take care for today. Of course, we'll be having them come back in our 2022 calendar year. So make sure you are looking ahead and looking at our calendars. And I will be sending a follow-up email, everyone, with the information on the screen you see above in front of you with Raphan Law Partners and Matthew's information. Okay. So take care, everyone.
Thank you, Kara.